introduce here. So our topic is Anti-Suit and Anti-Arbitral Injunctions, the Achilles heel of international arbitration. Obviously, this is one of those topics that interplays very nicely as between courts and arbitration, like it or not, or want it or not. And the topic, but before that, I will introduce this panel. So we are very, very fortunate to have Justice Ravindra Bhat. Justice Bhat to my left is former judge of the Supreme Court of India, retired in October 2023, previously served as Chief Justice of the Rajasthan High Court and was also a judge of the Delhi High Court for over a decade. And during his long and exceptional judicial career spanning nearly 20 years, Justice Bhat has sat in multiple arbitration-related court cases and has participated in law reform projects for the Indian government. Justice Bhat was a member of the Justice B.N. Sri Krishna-led committee to review the institutionalization of arbitration in India. So Justice Bhat, if you don't mind, and with a bit of warning, a lot of the trickier questions I've got have your name next to them. Next to Justice Bhat is Ms. Anuradha Dutt. Ms. Dutt is the founder and managing partner, very well known of course to everyone, of DMD Advocates, Delhi office, and the head of the firm's litigation group. She has several decades worth of experience in domestic and also international arbitration and litigation matters. Most notably, she successfully represented the Vodafone Group in its landmark investment treaty arbitration against the Indian government and related court proceedings in the courts here in India. Ms. Dutt acts regularly on complex and high profile is a bit of a criteria, I think, for her practice that matters are high profile and complex before they come to her docket. And Ms. Dutt has featured in BW Legal World's list of 100 influential women driving change in the Indian legal ecosystem. It's something I've been monitoring for years with the hope that one day I'm going to find my name there, but it feels like I'm really far. 500 London APAC survey of senior advocates. Another list that I monitor, by the way, in my spare time, and is currently a core committee member of the ICC India Arbitration Group. And to Mr. Sen's left is Ms. Charanya Lakshmi Kumaran, and she's an executive partner in the Commercial and Regulatory Disputes Practice at Lakshmi Kumaran Sridharan, and an advocate on record for the Supreme Court of India. She leads the commercial disputes practice of her firm in Delhi, and has experience in extensive types of matters representing clients in high-stakes arbitration matters across a variety of sectors, particular expertise in taxation and regulatory matters, and has been recognized by the BW Legal World as emerging woman leader. I need to talk to you both about how to get on this list, I think, after this. I haven't put it as a formal question, but I might well do. I'm going to start by just saying, much as I like talking, and those of you who know me know that one has to cut the mic for me to stop, I'm going to just say a couple of things about this topic, and I'm going to dive straight into being in the enviable position of putting questions and then not having to deal with the answers to them. This is a very, very interesting topic in this country in particular that sees vast amount of jurisprudence in the sense of interim jurisprudence. Most matters, I would take the liberty of saying, usually start with some kind of injunction application. You probably agree with me. But what we have here is two sides of this coin of interim relief. One is the anti-suit, where of course you are trying to stop somebody doing anything other than going to arbitration, so you're trying to stop a court proceeding. And the other one is the anti-arbitration, where you are trying to stop the arbitration proceeding, sometimes in favor of a court proceeding, but sometimes just saying actually you don't have an agreement to arbitrate. So I'm going to get this panel, and I'm going to start with not actually pointing to anyone in particular, so feel free to respond to the first question, whoever would like to. After that, I'm going to direct questions to individuals, so again, apologies for, for calling on you. So maybe just by way of recap, what's the difference between the anti-suit and the arbitration injunction? There's obviously lots of differences in the legal test, in how they're used, in how India sees them by way of when they're granted and when they ought not to be even applied for. But my purpose of asking this panel this question is, when I ask you, what's the difference between anti-suit and anti-arbitration, what's the first thing that comes to your mind to distinguish them? And Justice Bhat, maybe because you are sitting next to me, if you don't mind.
Yes, I think the fundamental distinction which stares you at the face is that in an arbitration scenario, unlike an anti-suit injunction, The parties have agreed. The parties enter into an agreement to choose, have a forum of their choice, which is arbitration. So the other party, which is usually claiming to be aggrieved and seeks an injunction, wishes the party not to press its claim or even file its claim. So that's the way usually I think these things are proceeded. That's the basic, that's where you part ways between an anti-injunction suit and an anti-suit, anti-arbitration injunction and an anti-suit injunction.
Yeah, interesting distinction.
I totally agree with him, and I think in an anti-arbitration injunction, the second thing is now what we have developed all over the world, competence principle.
Yeah.
So that also plays a significant role in deciding whether to injunct or not to injunct an arbitration.
And follows on from itself what you said about being aggrieved.
Well, that's covered.
Basically, there's party autonomy.
Yes.
So already covered what the difference is. I think one important aspect to be kept in mind is that the courts have to be far more careful and extremely cautious while granting an anti-arbitration injunction for the reasons Justice Bhat just stated. And therefore, that is an important factor, much higher than even a normal anti-suit injunction, which you would grant. Either if there is no arbitration agreement in place, or it's by fraud, or the party says that it has not signed such an agreement, those are issues there. Arbitrability is also another point which recently judgments like Vidya Rolya, it's an Indian audience, so I can, and for your sake, that this is it's one or two the issues of arbitrability, what disputes are arbitrable, which are not. So I think that distinction must be kept in mind. And one quick thing, I was a bit curious. May I ask a question to you, if you don't mind? And I was curious about the fact. Achilles heel. I mean, what's the connection, and how do you feel that it's an Achilles heel, anti-arbitration and anti-suit? Since this is a recap issue, so I thought I'd just check that.
Yeah, it's actually it's an interesting one. I mean, there's a question mark at the end because there's an underlying premise that needs to be questioned. Is it an Achilles heel of international arbitration? So perhaps what I'll do is get your views, and I will answer that at the end. But I will. And actually, do you think it is?
Well, I'd say it's not, because it is assisting and aiding arbitration. And I've never had Achilles heel, but I suspect it's painful. But there's nothing, I mean, the pain, if any, of the Achilles heel, I think would be diminishing. But nothing to compare with the situation where a much bigger pain is in the offing. The recent memorandum by the government, which is proposing that its proposals that try and avoid going in for arbitration in procurement contracts, etc., above 10 crores. So that is, I mean, more than anti-suit and anti-arbitration. I mean, it's the government which is the largest litigator in the country. For reasons, I mean, it's not entirely unjustified, there may be problems. Feels that arbitration may not be the best way to go forward. So I think that's a bigger pain we need to worry about.
Yeah, that's an interesting point. And as I say, I won't dodge it for the off the hour and respond to it. No,
No, I absolutely agree with all my esteemed panelists. Competence becomes a very relevant factor in deciding, and that's why when we try and apply for an anti-arbitration injunction, that really stares you in your face. The tests that we otherwise, there's a presumption when we talk about, how it is difficult to get an anti-arbitration injunction, that it is easy to get the anti-suit injunction. It isn't. It is, I feel, equally hard. And I will come back on some of the tests, if really there is a difference or not. But this point, the fact that you've chosen your jurisdiction, now the point to go and argue that, that is oppressive, going to another jurisdiction of my choice is oppressive, to show the threshold is very, very high now that you need to cross.
That's actually a really interesting point, Charanya, about this presumption that the anti-suit is going to be a little bit easier as a battle. Is it because there's not that many cases on anti-arbitration out there? Is it because the test is genuinely different, as you say? And maybe Justice Bhat, back to you. If I were to ask you, what, in your view, are the criteria for the anti-suit and anti-arbitration? So if you're sitting and somebody comes and makes an application your mind, what do they need to show in each instance?
I think as far as anti-suit is concerned, the path is very clear, although the case law isn't consistent, but the path is very clear. Modi Entertainment has laid out a very cogent and I would say fairly exhaustive list. Whether you have an exclusive jurisdiction, whether it is a neutral jurisdiction, in which event does the contract speak, and then what is the hardship which you want to avoid, and so on and so forth. So when you look at an anti-suit injunction, the tests are fairly exhaustive. Now when you come to an anti-arbitration scenario, on the other hand, apart from Modi was not on anti-arbitration, we have other judgments which are also, I would say, they have given a clear pathway. One is the one thing which you have to look out for in anti-arbitration suits is whether it's a part 1 or a part 2 arbitration. If it's a part 2 arbitration, which is a foreign seated one, there could be a different test. And we have this Kumaran cementation, which is a 2012, where the ruling is that a civil court cannot go into the existence, so basically the competence. And then we have a host of other cases which have said that except when it comes to fraud. And there again I would like to add to what Mr. Sen said. Fraud is now non-arbitrable in terms of 2 judgments of the Supreme Court. And then we have this Haldia Petrochemicals, which says that seeking an anti-arbitration injunction in foreign seated arbitrations suit is not maintainable. And interestingly, one of the reasons given is the bar to a judicial remedy under Section 5 the moment you have an arbitration. So that's an very important consideration. World sport, of course, there is a little bit of a departure there, because they say that there is no inherent bar. That's where I think philosophically there is a clash. And then we are awaiting further ruling in Anupam Mittal, which is, you have a separate question on that, so I'm reserving my fire on that.
Yes, and please do, because we are going to come to that topic, of course. It was like Bangkok in those days. These days you can't do a seminar like this without talking about the commitment, so we'll definitely come back to that. Mr. Singh, can I just ask you, just as well, to refer to your point earlier, I mean, what are the differences in approach? And Sir set out very clearly and, obviously articulately the Indian position. How about other jurisdictions? How do they sit? Are they clearer? Are they further ahead in how they view Anti-Suit Anti-Arbitral?
So I'd like to, we take the 2 the types of jurisdiction, that is the common law and the civil. Common law principles are similar. I mean, if you look at the Indian law which is developed, it's more or less on the same line as the English law. If you look at the common law country jurisdictions and their injunctions which they hand, but since anti-suit and anti-arbitration injunctions are a species of injunction, they are very comfortable giving it. The second important aspect is one of the considerations which weigh in their mind is comity, because of another jurisdictions I involved, but it's not an overriding concern. And I'm stressing a bit more on comity because if we come to the civil law jurisdiction, say like France, in those cases the approach is more that you decline jurisdiction if already a court is seized of, another court is seized of the matter. For example, you have the French Civil Code, if you look at, there is the Article 1465, which again deals with the competence principle. And there is a positive competence principle and a negative. Positive that you, if there is another court which is already seized of the matter, you will decline to exercise jurisdiction. There is also the principle in France that if there is an anti-suit injunction which is granted, it could be enforced in France. That won't be a problem. And in fact, that was the Excalibur case recently in England which dealt with this issue, that it does allow. So the French, if we look at the French and the civil law countries, European regulations, for example, talk about the fact that there is a conflict and forum non-convenience is not really recognized under European jurisdiction. So the civil law countries are more by courts, dictated by courts, dictated by committee. That has a much stronger emphasis there, as opposed to common law countries, where committee is not is there, but it's not an overriding concern. And the Anupam Mittal, just briefly to touch upon it, showed how India was saying that committee really is not an overriding concern. Singapore, the judgment in the Anupam Mittal, took a slightly nuanced view because of its legislation and said that committee is also to be taken into consideration. It had more flexibility and said that if a foreign jurisdiction is there which recognizes that a dispute is not arbitrable, even Singapore courts, as long as it is not against there, would accept that. So I think to put it in one line, committee is a very important factor, I think, in the difference in approach. And the code, the structuring of the code is important in that, as opposed to the civil law, common law, where there's more flexibility.
And that's interesting, the division between civil and common. In some ways, and if you look at other topics, actually the jurisprudence here has often kind of almost taken a little bit of this and a little bit of that in terms of civil and common. And that's why sometimes the Indian judgments actually set out the law, the test more clearly and in a way that applies more across the board in other jurisdictions, I would say, as compared to what we've seen of other courts. But nonetheless, in India, we haven't seen that many, and Charanya, you made this point earlier, decisions, particularly on the anti-arbitration side. Why do we think that is? And actually, sir, maybe I'll come to you after Charanya, as well as even anti-suits. If you look at the number that come out of places like, say, England, Singapore, Hong Kong, and jurisdictions like that, it's pretty routinely coming out into judgments that uphold a pretty similar line of the legal test.
Can I have a word?
Please, sir.
Just on the previous topic, there's this recent judgment in England, ENCA.
Yes.
Now, ENCA is very interesting because, we are steeped in common law, but ENCA also gave a different kind of direction to this whole concept of anti-suit injunction, which involved an inquiry into the law agreed upon for the arbitration agreement, law governing the contract. That's very interesting because that was a Paris-seated ICC arbitration. And I think, I suspect, I'm not going too deep into the judgment, but English law applied. So that, I think, where they hitched the jurisdictional aspect and granted it. And that's been followed in two other judgments, Commerce Bank and UniCredit.
Yes.
So I think there is even in common law, there is a slight departure. I remember the old time, I used to do a lot of banking law. So English courts always had this very expansive view of jurisdiction. Are we reaching that? I wonder whether we're reaching that stage that, it's almost like a universal jurisdiction.
And so that's a really interesting point. In particular, a lot of the back chat on ENCA, of course, was a question of whether the English courts would have decided it differently with anything other than a French.
This would be a special scenario because we're looking at Russian sanctions now.
Yes, which is another entirely sort of, overarching area that warrants change or that's seen change. But actually, the ENCA point is very interesting because prior to ENCA, there were a lot of consistent English judgments. ENCA kind of brought it all as, do we need to specify this law governing the agreement to arbitrate? Where does the power to injunct come from? And asked the fundamental question, sir, that you're setting out, even if one thought that England had got it sort of clear all along. But if I do compare that with India, do we agree, or at least my sense is, there isn't as much jurisprudence as one would expect on this topic of injunctions,
yes.
Either anti-suit anti-arbitration?
Yes, absolutely. I think, first of all, it depends on, India is not one country, when we look at it, because as a litigator, when someone comes to you with a question, right, there are at least 7 or 8 different factors that go into even advising, what is the jurisdiction that you go to, where should you go, where should you not go, what are the repercussions. So because of that, it becomes very difficult to play this out, right? In India, even comity, we've seen this as a concept that's grown. In IP, we've got Sir's judgment in Alois Robin, which is an IP case on comity. We see a lot of cases on comity, from matrimonial cases, custody cases, international child custody cases. We see comity principles flowing. This, as Mr. Sen also said, is something that is there in the heart of, say, civil law jurisdiction, where they say, we must respect the fact that another competent court has jurisdiction over this, and then take a hands-off approach. If I were to say that is the reason why Indian courts have not done it, I don't think that is the reason. I think it's because they've not been approached as many times. That is my view, is that they've not been approached as many times. We have very clear now law laid down when it comes to natural jurisdictions. When we start with anti-suit injunctions, we have very, very good law now on what is natural jurisdiction. Is it because of where you're registered? Is it pecuniary jurisdiction? You have a host of reasons now why one chooses one jurisdiction over another. And courts also have been faced with this over the years and developed a lot of standards now. When it comes to anti-arbitration injunctions, I think this is really a field that is yet to be fully explored in India in terms of getting a foreign-seated arbitration injuncted, right? Also, the policy, if you see, for the last 15 years or 20 years, at least 15 years, what we hear from the Supreme Court of India is keep a hands-off approach. It is again competence, party autonomy, the fact that they have gone and submitted themselves to the jurisdiction of an arbitral tribunal, the fact that the arbitral tribunal has the power to decide its own competence, its own jurisdiction. There is that principle that always weighs. And in the last few years, we are seeing that weighs a lot on the judges before they enter into this arena.
And thanks, Charanya. I think this comment about comity and otherwise do courts consider themselves as having wide-reaching powers, a very interesting interplay. And so, you mentioned ENCA. I was saying before that I think a lot of English practitioners wondered whether, and French practitioners, and post our merger, as we now are A&O Shearman, my fellow partner is a French practitioner of as many years as I've been an English one. And we asked ourselves this question of, would the English courts have decided it differently if it was anything other than a Paris seat? Because of course the temptation is they want to take jurisdiction where the other side is France. And actually, does India also see that if they were approached more, would they consider that, we do have wider jurisdiction? And Ms. Dutt, I'm going to come to you on this because, of course, you are here, but actually you practice everywhere and you've seen a lot of international matters in your tenure. Do you feel that it makes a difference from the Indian court's perspective when they are met with that injunction application as to whether the underlying seat is here or foreign?
So, I think we don't go to the extent of English courts that we must assume jurisdiction, which they are very quick. But I slightly disagree with the line that you have mentioned and Charanya has mentioned, that our law is not developed. It's not the quantity, it's the quality that matters. And anti-suit, when we had Western Gecko, etc., Supreme Court judgments where they were easily assuming anti-suit injunction powers. But now Modi network has sort of, laid down, which is being followed. Anti-arbitration injunctions, I think, is also very clear that if it's an international, then the test of Section 45 of the Arbitration Act has to be applied, which is applied even in UK, Singapore, everywhere. That is, it's null and void, which includes arbitrability. It's incapable of performance, impossible. So these are tests all over the world, which now Section 45 and Section 8 also is is being developed. So I wouldn't say that the law in India is not developed on anti-arbitration or anti-suit. When we talk about Mittal judgment, I'm going to put a contrary view to what is being debated, because I feel that the Tulamagan judgment, I don't know if I'm pronouncing it right, I have a pronunciation problem from childhood, so please pardon me that. If you really follow that judgment, the judgment of Bombay High Court is not wrong. But that we'll cover separately.
I'm really looking forward to covering that.
But as I said, law is well developed. What is important is what is the public policy of a country. That's important, and how the judges embrace that and interpret. Now, in India, it's now well known that you need investment from foreign investment. Our recent, we were earlier banning Chinese investments, we were trying to ban, but now our economic policy says good investment from China is welcome. So the problem is our domestic investment, government expenditure is not sufficient for economic development. So we need, now if we need investment in India, the international trade, commerce must be strong. And if courts start interfering in, start giving anti-arbitration injunctions, that's going to prejudice international trade, the fabric of international trade and commerce. So our public policy has been, though I'm a bit confused now, as Prashanto said, because government on the one hand has set up a new institution to encourage arbitration, and on the same hand is telling its public sector companies for not to agree beyond a particular point. So I'm a little confused, but generally the approach, I think, in India is also similar to other countries, that hands off. Yeah. And I think we have sufficient jurisdiction on that aspect.
And Mr. I'm going to take that point even further by saying that when you look at Anupam Mittal, Singapore saw that as a novel judgment for an area that it felt had not been legislated or provided for in jurisprudence. So Anupam Mittal was seen as landmark in Singapore, despite Singapore seeing numbers, as you say, of anti-suit judgments. England has had to reform its statute, and even the reforms have been debated so much that the volume of jurisprudence prior to that really didn't add very much to when they came to the table to decide how to amend the legislation. So quantity versus quality, I think the point is very well taken.
Sorry, I just want to add to what I completely agree with Kumaran. Okay? And I think one of the points, just to add to her statement about investment, one of the biggest things that they want is certainty. When they say I'm making an investment in a country, I am very aware that it's going to have an entry point, it's going to have a life of its own, and it needs to have an exit point. And then we see during the life and exit, we see these disputes. But when I enter into this investment, then I should know reasonably what are all the weapons that be thrown at me, and I should have some idea of am I going to be on this side of the line or the other side, to prepare yourselves. Today, I don't think people are saying I don't want to fight at all. They're saying we are happy to fight, but at least we should have a sense right in the beginning that, is this going to be a fair play, or is the goalpost going to get shifted every time, which is what happens when you get these injunctions.
And actually that leads very nicely into the segue of the question I was going to ask Mr. as well, as a follow-on, if you don't mind, is you mentioned, investment framework, and I was saying that cases around other countries as well, even if they come in numbers, not too sure that anybody would be saying, look, our law is very clear on this, especially when compared to what we see here. I think it's exactly the same, in fact. But one area where we have seen less across most countries is the area of investment. And when, my question to you, Ms. Dutt, is when there is an investment treaty underlying and there is an injunction application, what should the court ask itself first, the question of whether it has jurisdiction or not, and where do you think it should come out? To Sharanya's question of they must have some idea.
So actually, bilateral investment treaty issues are slightly distinct from international arbitration, because most of the common law countries and even civil law countries are abiding by the New York Convention, which Delhi High Court says applies to bilateral investment in Vodafone case. But to my mind, this is a slightly different area, and I do feel that in bilateral investment treaties are not covered by New York Convention, and therefore have had a separate jurisdiction and development of law in that field from, there's one case, a Calcutta case, but that's slightly different. So what happened was that it's an India-France treaty, and there was a dispute, and they made the Port Trust a party. Now what Calcutta High Court did was, of course, said there is no difference between anti-suit injunction principles and anti-arbitration injunction principles, which we all disagree, and most of us disagree. But what they did was, they didn't stay the entire arbitration. They said vis-a-vis the Port Trust, this will not continue. Actually, there was no requirement to make Port Trust a party. So, and I don't know if you're aware, but ultimately India won, and France had to pay costs to India. So, so that, therefore what I was trying to say was, except for that one aberration, arbitration that was initiated under the Indo-Dutch treaty, and because of certain clauses in the treaty, it was found that the India-UK treaty may be more beneficial for the company. So we invoked the India-UK treaty too, on behalf of the parent company. Now, there was an ex parte stay granted by Delhi High Court single judge, but after hearing, he vacated the stay on the principle of competence. So, the principle of competence is being recognized in India quite a bit, and most of the judgments, if you see, which have rejected stay of foreign seated arbitration, is because of principle of competence. And here I have to also say that unlike UK, when we are deciding anti-arbitration injunctions and we are examining the arbitration, the scope of the arbitration clause, we take a prima facie view. Unlike UK, which takes a full merits view. We are following what Singapore also takes, prima facie view. So to my mind, this is important, because that's what even Vodafone decided. But what concerns me in this country, I apologize for saying it, but I have to be candid, is the delay in court system. Now, I'll give you a recent example of which I saw in many of the articles that are being written is of Beena Modi case, Lalit Modi case. I'm handling that case, but from the arbitration perspective, it's over. But what I want to tell you was that there was an arbitration clause in the family arrangement. Arbitration of ICC at Singapore. So Lalit Modi had invoked the Singapore. Beena Modi and her, those who were supporting her, they filed an injunction, a suit in Delhi High Court asking for an injunction against the Singapore arbitration that had been commenced on the ground. Now this is important because this has some consequence to Anupam Mittal. saying that this is a trust matter and trust matters are not arbitrable in India. Now, yes. Now, the defense raised was competence, and also that the trust had come to an end because of certain factual parameters in that case. So the single judge, on the first day itself, following Kavanagh and Nalco judgments of hands off, and section 5 which we have, which says notwithstanding any other law you can't injunct arbitrations, dismissed their suit. But when it went in appeal to the division bench remanded the matter and said, no, file a section 8 or a 45, file your written statement, and it should be examined in detail. The matter doesn't rest here. It's taken an appeal to Supreme Court on the question whether an anti-arbitration injunction can be granted in view of section 5. 4 years, almost 4 years this matter languished. The court didn't have time. It was mentioned about 10 times, but the court, I understand the court's predicament. They said, we have criminal matters, those take priority. I understand that. But the problem is that 4 years we were languishing, no decision, no hearing. So ultimately we had to withdraw the arbitration and file a suit in India where the hearing was faster. So, delay is something which I think the parameters are well established now in many judgments, but delay is something which, not just arbitration, in all aspects, is something which touches delaying pronouncements and hearings, is touching all of us in every aspect, including anti-arbitration injunctions.
And let's just pick up on that theme, and in particular, Mr. when you said, comity versus competence. That's sort of what we're looking at if one thinks about, the parameters of this discussion. And then let's come to our favorite topic, which is Anupam Mittal. I'm just gonna, in just a couple of lines, just remind everyone of the sort of setup. So there was a shareholders agreement. The law governing it is Indian law, right? So that's clear. The law governing the arbitration agreement is not expressly specified. So this is one of the features to Ms. Dutt's point about delay, that delays matters as to where should one even be and what's the scope or framework of governing law that should dictate. And yes, there may be a bespoke problem of delay in certain jurisdictions like here, but even just not specifying it creates that jurisdictional hurdle which one has to navigate in any court system. Singapore was the seat. The outcome was that there's an anti-suit injunction in Singapore against the prosecuting court in the NCLT proceedings in Mumbai on grounds of breach of the agreement to arbitrate. So, and the arbitrability, of course, of the subject matter under Singapore law. Now, Anupam Mittal, of course, then approached the Bombay High Court and got an anti-enforcement injunction against the anti-suit by the Singapore court. And then the Bombay High Court granted that. Ms. Dutt, you referred to that earlier, and we'll come back to this. And then the NCLT Mumbai after that issued the anti-arbitration injunction. So lots of kind of groundbreaking developments there as between India and Singapore, kind of headlines for most of us who follow these two jurisdictions very closely. The orders were primarily based on this point about non-arbitrability of the subject matter, right? So I'm going to ask a series of questions. The one question that has been debated, but we have the benefit of Justice Bhat sitting here, so I'm going to ask you quite candidly, do you think the Indian courts were right in granting the anti-enforcement injunction against the anti-suit and also the anti-arbitration injunction on grounds of non-arbitrability?
I think you can look at it from, depends on which premise you start with. You start with the premise that this is a Singapore seated arbitration. That's very clear. Then the law applicable, the curial court is Singapore. So and there is an arbitration clause. So if we follow the law as as it existed when the dispute hit the courts, the law is clear that you should not touch the arbitration. But I would rather frame this from another angle, that supposing supposing the arbitration had proceeded, then it would be an issue of enforcement, rather than an enforcement of the Anti-Suit Anti-Arbitration Injunction itself. Now, would it fit in the 45 category? Now, I don't know whether we have examined it from that angle. We have kind of preempted that inquiry by just getting into the enforcement of the interim injunction. So I think these questions these are larger questions which need to be addressed, and hopefully they will in the Supreme Court, because the appeal is pending. But going forward, again, there's an underlying issue of the substantive law. Is it as clear that O&M disputes have to be adjudicated by the tribunal? That too is an issue which, whether there is an exclusion at all, because there is no exclusion in Singapore, as I understand. If there is no exclusion in Singapore, is our law as clear? If you go to Booz Allen, which is Justice Ravindran's judgment, it's not as clear. He says winding up proceedings are non-arbitrable. So there is an exclusion of winding up proceedings. There is a judgment of the Delhi High Court which seems to suggest that O&M disputes are not arbitrable. On the other hand, you have Gujarat and Bombay which say that they are. So there is clearly a difference of opinion. And Vidya Trollia is, let's say, more of a general, there is no clear-cut yes or no on this issue. Whereas when we come to other areas, and this is where I draw upon my experience, when you take, for instance, don't get into company law, don't get into IBC, because I think even IBC is very clear. But you get into, say, patents or intellectual properties. It's very clear that when it comes to infringement of patents, you cannot arbitrate. Whereas when it comes to licensing or things like that, or even infringement of trademarks, they are arbitrable. And in fact, I have received a couple of them. So the point is, what is and what is not in now I think there is more clarity, not in the arbitration, but in the mediation segment, because there is a negative list, so to say, as to what should not be mediated, and the government has the power to notify what should be there in that. Like, for instance, environmental complaints. These are not per se arbitrable. So I don't want to expand on that. The point was, I think there could have been a different result if we had seen this from a different perspective, because the real lens is 45, and that has been somehow missed.
And so I really like, first of all, we always do these things and you get an idea for the next topic or two, and a lot of what's been said here I sort of wrote down as, hey, we can talk about this next, particularly your point about mediation and when you compare to arbitrability. But I like the way you started that answer. You said it depends on which premise you start with. So what I'm going to do is just change or tweak the premise a little bit. So Mr. Sen, what if there was an express choice of law governing the arbitration agreement and it was Indian law? Do you think that would change the answer?
Yes, I think that would change the answer, because then Singapore, and in fact that kind of, I want to make a segue here. Important thing to note about the Singapore jurisdiction is that it has a separate law which is dealing with international commercial arbitration. And in that, it defines foreign policy quite widely. It takes into account foreign policy of other jurisdictions also. Public policy of other jurisdictions also. And in fact, the reasoning given in the judgment is that had the arbitration law been governed by, law governing the arbitration agreement being Indian law, and Indian law says that it can't be, and if that was the argument that it can't be, it's not arbitrable, then the Singapore law would have respected that. Now, this nuanced approach to comity and to an international flavor which is there is because Singapore has a separate international commercial law dealing with international commercial arbitrations. And I think this nuanced approach is commendable for India also, and which is one of the reasons why I feel India must have a separate law. Because what they have done is they've taken the UNCITRAL model and covered both domestic and foreign commercial law. And as a result, what happens is many times pronouncements on domestic arbitration issues can create ripples in the international commercial world, thinking that's how the courts are thinking, which may or may not be the case. One very important example, which I would give, a very recent one, is the curative one. Now, the curative one kind of sent shockwaves all over that, how the court intervening, etc. But the point to be noted is it was with respect to a domestic arbitration award. And even Indian practitioners in one of the conferences I went abroad seemed a bit muddled about it and seemed to indicate it could extend to international arbitrations also. So I think, coming back to the question that if it was Indian law which was governing the arbitration agreement, Singapore would have given way, and I think that's a far more sophisticated approach because of the structure which is there, which may not be in India. One quick point I want to raise about the experience. You see, interestingly, BALCO put in the seat concept, which is an international law concept, into domestic law. And initially I was a bit taken aback by it, but I think overall it has worked quite okay, because India is a large country with a large number of states with different high courts which are there. So coming to this experience of anti-suit injunction, if you talk about forum non-convenience, it is there in section 24 and 25 of the Civil Procedure Code. That principle finds mentioned there, because courts can transfer, Supreme Court can transfer matters from one jurisdiction to another. High courts and district courts can transfer. So that is very much in our DNA in that sense, if you were to speak. Committees in our DNA, other high court jurisdictions when they are seized with matters, how do you deal with it? So I think that it is endemic in us in many ways because of the size of our country.
I just want to make a comment on this committee issue. See, we are all steeped in this silo of commercial law and arbitration. What if the issue were custody? And that also is tied to your question about why don't we have jurisprudence. If you make an inquiry into that, it may not be anti-suit, maybe anti-enforcement. Not articulated as such, because then the courts look at a larger principle beyond law. They look at the Constitution. Because we don't go by committee, and we are not a signatory to the Hague Convention. So, and we have we have not been part of it. Therefore, the courts except exception have not gone by committee. They have gone by what is called as the best welfare of the child. And there is really an issue internationally, because a lot of provincial courts in Canada and US and state courts in US are very sore about the fact that Indian courts do not give respect or honor to this principle of committee. So I feel that when you talk of anti-suit, really we have to look into anti-enforcement. The enforcement issue of whether the foreign seated courts injunctions are honored here or enforced. And then one of the earliest judgments is from India on anti-suit, which is tractor export, which is 1969. And then we didn't know it is not 1940, it is the foreign awards enforced 61. We didn't have the so then lines were not as clear cut. Therefore, I think that's one aspect which should keep in mind. And then about volume 2, I have a slightly different perspective. In support of what Anuradha says, that Supreme Court seems to have delivered some. High Court has dealt with this issue in 77 cases or mentioned, and Bombay in 34. So it depends on the subject matter.
Can I also just say I'm really impressed at just the amount of, I guess, thinking and work, and this is partly why also we chose you as panelists for this topic, because we knew that you'd come kind of with these points, like how many cases have there been, what have the individual judgments said. I find that really interesting, and as I say,
just one more, sorry, yes. I'm hijacking. Just 2 minutes on this investment treaty. I'm not making any comment. I think, to my recollection, India has derogated from the idea, or rather not been ratified the New York Convention bit, which talks about whether this is an exit kind of award is a commercial award. And that makes, that's even the Supreme Court, to my knowledge, has not dealt with it, although the occasion did arise. And then interestingly, my own High Court seems to have, even both the High Court seems to have overlooked this point. And the second point which I wish to make is not either in favor or against, but the point is the agreement between the states. So then and secondly, it is the treaty, most importantly. And these treaties have not been enacted into law. So then the jurisdiction that the the tribunal derives is because the private entity is enabled to approach the state with a dispute and make a claim. Now this is outside of the arbitration mechanism unless we have a codified investment treaty law in India, which we don't.
That is another topic actually, but in itself, just that last comment you made, sir. But can I just ask maybe Charanya, I'm going to change another facet of this judgment. What if the shareholders agreement, and how would an Indian court view it if the shareholders agreement was governed by foreign law? So say for instance governed by English law, Singapore law, not Indian law.
So thereby saying that it would have been arbitrable in that sense. But the question is, you still have the threshold of 48 in India. So the enforcement is happening here. Then I think it will still be a question that in India, could this be arbitrable? And therefore, I think you would come to the same conclusion. That is my view.
And Ms. Dutt, if I may ask you, and I know you said earlier you're going to tell us your views about this. I'm going to put a premise, and then I'm going to let you, of course, tell us how you really feel about it. But do you think there would have been a difference in who was approached? So if, for instance, it was the Singapore-seated tribunal as opposed to the Singapore court that was approached, would that have changed the current?
So I'll answer this at the end of my analysis.
Yes, please.
So when Singapore Court of Appeal, as it's called, decided this Arun Mittal matter, what they did was they said there is a distinction between pre-award stage and post-award stage. And then in the pre-award stage, they said that they will examine the arbitration agreement and which law governs the arbitration agreement. On their analysis, they found that the arbitration agreement, even though the disputes were to be settled by Indian law under the contract, but because there was nothing said regarding arbitration agreement, they came to a finding that it will be governed by Singapore law. And in Singapore law, they examined various provisions, including Section 11, which talks about public policy and if there is a bar. And they say that this would not be a bar. Oppression mismanagement petition would not be a bar under the Singapore public policy. And then they come to a finding, they do examine the complaints made in the petition in the NCLT by Arun Mittal and say that all these are encompassed in the shareholders agreement because the clause said disputes regarding management also to be referred. So they come to a finding that all these disputes emanate from the shareholders agreement, and therefore the petitioner there, Westbridge, is entitled to an injunction against the NCLT proceedings. But they also say, they are also cognizant that Bombay High Court is seized of this issue. So what they say is, we will not wait, let the arbitration go on, at least parties will know what is the strength of their case. I think that's a little weak argument. that you say that I'll wait, but let it go on, because there are expenses involved. So if you have decided to give an injunction, give an injunction. Now my problem is when I see the Bombay High Court judgment, they have refused to enforce the anti-injunction given by the Singapore Court of Appeal on the ground that ultimately when this award comes, and if it's a presumption is it's against Anupam Mittal, if it comes for enforcement, then under section 48, if an issue is not arbitrable in India, then you can't enforce it. So why have an injunction? Now, I heard what Justice Bhat said. There is a section 430 which says wherever there is jurisdiction of NCLT, which includes operation mismanagement, you can't have either a suit or any proceedings, which will obviously include an arbitration. Now, the distinction made in Singapore judgment is that pre-award and post-award are seen separately. As I said, when I started reading the material you suggested, the Tomulugan case, please see para 72 of that case. I actually got that judgment only because we don't read it every day, so I'm not sure if I don't want to misquote it.
I was worried you might ask me what it says.
So para 72 actually says there is no difference between pre-award and post-award. And if something comes for enforcement and it is not arbitrable, which Tomulugan puts in null and void of the section 45 principle, which they also have. It says there is no difference between pre-award and post-award, and if in post-award it cannot be enforced, you cannot injunct. Now, Justice Menon is party to both the judgments. Now, the same para does talk about what is the law that is applicable to the arbitration agreement. But to my mind, that's a separate point that is being considered. Now, if I go by Tomulugan ratio, of course in that case it was a domestic proceedings and they hold that there is no bar to operation and mismanagement, and therefore, therefore they grant injunction. But if this reasoning is correct, that there is no difference between pre-award and post-award jurisprudence, then Bombay High Court is correct. Presuming that 430 is right. Because from Haryana Telecom onwards, there have been several judgments. But I must also point out a distinction which one of the judgments in NCLT has picked up. Section 41B of Specific Relief Act says that a court can grant an anti-suit injunction only vis-a-vis a case that is below, in a forum below it. Now the NCLT has said that this means that NCLT has no jurisdiction to grant a stay of an arbitration, a foreign seated arbitration, because that's not a forum below the NCLT. Now, coming to the problem that I am facing is the NCLT judgment where in Arun Mittal case, where there is a stay given of the foreign arbitration. Because the Bombay High Court only refused to enforce. The actual stay has been granted by the NCLT, where Anupam Mittal approached for a stay. Now that judgment has recognized this McQuarrie judgment of NCLT, but does not deal with it. And most importantly, I think where the Singapore court made a mistake which maybe a tribunal would have examined. There was an argument that please see that this petition filed in NCLT is dressed up. That is, actually it's shareholders' dispute. You are only dressing it up as operation mismanagement. Now this was a point raised before the Singapore court, but they did not. They examined it and said it's within the arbitration clause, but they don't give a finding. I think if it had gone to a tribunal, it may have given a finding on that. Now the NCLT in India does not examine, whereas there are judgments of Rakesh Malhotra, etc., of Bombay High Court, which say that you should examine whether this is a dressed up petition, a genuine petition, even if it's a prima facie look, but do examine that. Yes, but the tribunal in Arun Mittal case is so influenced by the Bombay High Court judgment that they either do not see 41B and the argument that NCLAT, which is binding on it, had examined and said you don't have power, nor did they examine whether this is really a dressed up issue. So I find fault in the NCLT judgment in my analysis, not the Bombay High Court, because as I said, if you agree with para 72 of Tumurugan, then pre-award and post-award there is no difference. Then I may say that there is some rationale in that judgment, although I don't agree that they have put it on two bases. One is 48 you can't enforce, second is he'll be remediless, which he will not be because there is an arbitration. So.
And the Court of Appeal in Singapore tries to deal with Tumurugan, but as you rightly say, they don't actually reconcile the two.
They just say it's within the clause. They don't say, they don't examine the petition whether it's dressed up or not. If that finding was there, I think then it may have been easier for courts in India to deal with it.
And actually, Ms. Dutt, your view on the NCLT decision, I mean, we know that everything's being appealed right now.
Yeah, it's an appeal, I believe, the NCLT.
And I think the Bombay High Court order as well. Can I ask you, sir, do you think that the last outcome will be different to where we are now? Maybe just crystal ball gazing from England?
I really can't speculate.
Astrologer.
The only thing which actually astounds me is that so much of energy and time is spent on the issue of jurisdiction and nobody's really got onto Anuradha mentioned about expense. I think there is no dearth of expense here. Any amount of money is being poured in, and it's essentially a private dispute. So the point I'm making is I'm again going back to her comment about courts not finding enough time to deal with cases. Now, if we are stuck with these, and you have let's say 10 of them, and these are, time stands still in these cases in India. So and then an average judge, the best of courts, I don't know what the workload is. I think now it's 80 cases a day. So we have talked about a lot of reforms, changing the Arbitration Act, Commercial Courts Act. But unless we increase the capacity, double it or triple it, I don't think we'll see any significant change. Why it happened? Because of that. And we simply just have not learned the lesson.
Maybe I can only think for arbitration because we are talking about arbitration. I think there needs to be a separate arbitration bar, because what's happening, which even international arbitrators who come here say that people say, oh, after court, please have it at 4 or 4:30. Oh, I was stuck in traffic jam. So we need to get out of this. And there should be a dedicated benches also in High Courts and Supreme Court, so that these issues can be dealt with. And I somehow feel that this is as important as anything else because of international trade and commerce and the fact that India needs investment and, as she said, certainty. So these, to my mind, For arbitration, there should be a separate bar and there should be separate dedicated benches who hear this. Maybe one step ahead.
And just to the points about cost versus delay, giving credit where credit's due to the Indian courts as well, they were aware, right, that the parties had flown to start the arbitration hearing, and it was the night before the hearing was meant to commence. And of course, expenses had been spent by lawyers, not me, but by lawyers to prepare for this arbitration, only to be met with this injunction. So it really brings in all the issues of, yes, the courts actually...
I was hearing a podcast the other day, and one of the cases in India, 45 adjournments on a bail case. So that's the kind of delay we are talking about.
Actually, speaking about delay, one interesting point made in the Bombay High Court judgment is, they say that it should have been brought to the notice of Singapore that this application, which Singapore said it's likely to take more than 12 months, and which is why they gave this interim order. It should have been brought that within 12 months, normally this application at least would have been decided. And that's the observation which the Bombay High Court makes, which was not brought to the notice of Singapore apparently.
Yeah, and actually there is a question there.
It was brought. It was brought.
No, not within 12 months. The Singapore court judgment says within 12 months it's not likely to be decided.
Right.
And that weighed with the Singapore court.
Which is correct.
No,
and therefore they say let the arbitration go on, and at least each party will know the strength of its case. That I found a little peculiar.
And actually this brings me to maybe the final sort of set of questions. I'm going to put it to the entire panel, in fact. But it is exactly this point about, I wouldn't call it criticisms, but just observations and where do we go from here. So Mr. Sen, you asked me at the beginning this Achilles heel and why did we choose this topic? And I think that's it's a good question, right? I mean, first of all, of course, the team and I sort of thought about this topic and what do we call it? How do we lure this panel to come here and talk about it the way you have, well preparedly as well? Achilles heel is a weakness despite overall strength which can lead to downfall. That's what it stands for, okay? A weakness despite overall strength. So we're sitting here the premise of the system works as good as any system can. Of course, it's got problems, but does this problem in particular lead to downfall is the question that we are met with. So that's why I didn't answer it at the beginning, because what I wanted to do here, so thank you for preempting that actually and setting the scene for me, is to ask the panel, do you think, and we've heard quite a few things about arbitrability, delay is a very, very big point, which of course does kind of lead to the justice of it all. The committee versus competence, and then of course does it matter which court you go to first, and then is the obligation of the parties to then update the respective jurisdictions as to what's going on. Let's take all of that, put it against international arbitration as a system that works as the premise. Do we think that this idea of anti-suiting or anti-arbitrating, is it going to lead to ultimately the downfall and a reversion back to courts? And I asked that question in this jurisdiction because of the comment made earlier that there are initiatives either way coming from the top, that perhaps in some cases courts are better than arbitration. Do we think that this is actually one of the reasons that people will start to think it's really tiring to fight jurisdiction, anti-suit, anti-arbitration, spend lots of money on people like us before you even start to argue the dispute? Is that going to lead to an ultimate downfall of the system? I put that question, and unlike my usual directional way, I'm actually going to just say whoever wishes to speak first, please do. But I'm going to make sure each of you do, if you don't mind.
Well, there's a disadvantage. The framing of the question, Achilles was brought down in the sense that was his fatal, that was the only weak link in his armor. Because his mother had dipped him into the immortal, the river of immortality. But, well, I don't think this is our Achilles heel. We have shown remarkable capacity to self-correct over the last so many years. I think white was one red signal for us, and then we had Banco, and there has been a fairly good, let's say, robust development of jurisprudence. What is needed is, yes, capacity building, sensitization, and I think what we need to do is strengthen some good institutions, and not just the courts. We have to look away from the courts, and Anuradha's point is absolutely right, that we have to have a robust arbitration bar and not a part-time arbitration bar, which is what is happening. The attempt in our report 7 years ago was to create a body which would be a kind of market-driven body, which would be industry-dominated or let's say staffed. There is the Arbitration Promotion Council, which would evolve standards and accredit institutions. But unfortunately, it's taken a completely different direction and it's not taken off. But going forward, I think it's not just the state, unless the industry shows interest, and the bar also equally takes that initiative to not just talk of an arbitration bar, but actually do it. And there we have to plan ahead. We have to have more scholars. We have to invest more in, endowments, scholarships, and make sure that people go abroad and bring back this culture and live it. So unless you foster that kind of thing, it can't happen magically overnight. But yes, I am always an optimist, and I do believe that things will settle down. Maybe Anupam Mittal could be a new threshold, and we could call, because I'm not optimistic about the fact that there would be more judges or more arbitration benches. For that matter, Charanya knows how it is on the tax side. So the more we talk of having more specialized people, which is badly needed, at the same time we have to develop that capacity, both in terms of personnel, and it's not just enough to have courts and staff them with anyone. You have to have people who are sensitive to that class of litigation, which will take some time. I don't think I'll say.
That's, really excellent summary.
So, I absolutely agree with Sir. I had very few occasions to disagree with Sir, though he disagreed with me, I think, in court. But no, I think, I don't think it is an Achilles heel, because, as we've just seen, the resistance, the resilience that our system shows it's always been there. Sir said self-correction. I think there is a resilience in our system. Okay. Having said that, Achilles heel, I don't think it is anti-arbitration suits which really will be an Achilles heel. There are other systemic issues, which will actually, I won't say lead to the downfall, but prevent the kind of robust environment we are looking for in India for arbitration. And I agree with Sir, even when it comes to capacity building. I think that is really the need of the hour, right from the bar to also the, when we have technical arbitrators, are we equipping them with judicial background, right? When we have judicial arbitrators, are we equipping them with technical know-how? Because it's very complicated, infrastructure, technology arbitrations, they're all very complicated. And as we are going forward, each of those disputes is getting more nuanced, more complicated. They're not money decrees anymore, So those are issues. And similarly, the problem we face with technical arbitrators is natural justice. How do they take evidence? Are they ready to take this? Are they ready to hear? Many of these things, they come with a preconceived notion that, lawyers will always, try to delay. They will always. So that there are some of those notions. It is going to take a while, but it has to be, an all-industry effort.
Thank you.
Yeah.
Please.
So, I often kind of wonder whether one should take a linear view of things and saying there's a progress in future which will happen. It's always a mixed bag. Going back to Balco, when I was involved, we took a study. Of course, that was many years ago, and I was in a different avatar. Now I'm very pro arbitration, etc. But at that time, we moved a section 34 in a very remote district of Korba, which meant that the whole machinery of Katsi had to come down to that district court, which didn't understand English, and that was, of course, a strategic move. But on the first day when I went there, the judge, before issuing notice, pointed out to me. He said, "You'll have to deal with this, and this judgment." There were all the latest, up to date he was on what were the judgments which were involved. I was quite taken aback. Fortunately, he was transferred by the time the next matter hearing came up, and it went up a long way. So there is within the system a lot of resilience. Number two, as far as arbitration bar is concerned, taking from what Anuradha said, you see now because of section 29A, arbitrators are very conscious that it should be done within time. I mean, of course you can get extensions, but a good arbitrator wouldn't like to go into a situation where extensions are required. In fact, strangely enough, I'm in an arbitration and this happened yesterday. Technology is which is creating the problem, because this counsel on the opposite side was arguing and he said, I've got an extremely important call, I'm very sorry, I have to, break off. So he went off on the call. We thought it was a personal call, but it appears he went for a quick hearing and on the screen and then came back again for the arbitration. So I think those will smoothen out, but I think that will set in the arbitration bar and stricter timings.
Ms. Dutt, just before I call on you, so there's a really well-known Hong Kong decision. Actually, the judge is a dedicated arbitration judge, and she comes from Legacy Allen and Overy, so I say this with a great degree of pride, who decided that an award should be set aside because, and the proceedings were on the ground in the mainland. The arbitrator was shopping around in a mall and hearing the matter at the same time, so that every time the parties were making submissions, he had his phone and was kind of looking around at things and then sort of going, I follow. And she said, well, that's not a reasonable opportunity to be heard, I'm afraid. So, we sit here about India and its progress. India sees so much jurisprudence and gets it right so often that, when you do take a very kind of, macro comparison, we could sit here literally all day and talk about judgments that are so interesting. Ms. Dutt, I'm sorry, I wanted to hear you.
So, to my mind, as long as India requires investment, any businessman who's coming from outside India will insist on arbitration, because our delays in our judicial system are pretty well known. So I don't think India's public policy can wean away from international arbitration because of the compulsions that we have for our economy. And as long as that remains, I don't think the system will break. And as I said to you, quality I do find, quantity maybe less than Singapore. But look at Singapore. Nobody used to go earlier to Singapore for arbitration. That country made it a public policy to ensure that this becomes a destination, and see where they are now. So if India makes that concerted effort, we can also become a destination. But with all due apologies, judges should not take 2 steps forward and 1 step backward or 3 steps backward. That certainty should come, because I'm saying because of what happened in the stamp duty case. I mean, that was really shocking.
I've got another couple of topics that I've picked up for next time, so do watch this space on what else we might.
I just want to have a laugh,
Please,
but
sir.
not because of what Anuradha said, which is she's absolutely right there.
She opened a can of worms, I'm afraid, right?
No, I think she's right, because when we do tweak, we believe it's a very small tweak, but then it turns out to be a tsunami. But more importantly, it's like a regime. When you make changes in a regime, transition is the most painful, and we experience it most often in India, and it's not good. But I want to make an additional point, and it's not about ADR or arbitration being only to attract investment. I think we are looking at internal investment, and from the citizen's point of view, easy access to swift justice. So therefore, I think there's a wider audience there. It's whether you look.
If one looks at the reforms that are proposed, that also kind of brings together just how little England, I think, had in terms of clarity of what they want.
I would only react to this, that we have our own moment of epiphany, the interdigital, but seriously, I think extreme responses do evoke this kind of reaction, let's say. So the Wuhan court anti-suit injunction.
Xiaomi case.
We came out with that. We call it anti-suit, but it's really an anti-enforcement.
Yes.
So.
But there, of course, the court held that the 2 subject matters were different. This was a patent issue, infringement issue, and that was a pricing fixation issue, so there was no commonality, and also they said that it was obtained secretly, because it was never
There was
served.
no,
So-
because the SEB dialogue requires notice. That was,
Yeah,
they
that-
went to rush
that-
to the court without issuing
Yeah.
notice to the
But
patent.
I just have one little difference on committee of courts, that it's not important in India. I absolutely agree that, say, custody or marriage cases, we do not. But in commercial cases, we do, because all judgments say that you must have jurisdiction over the person.
That's
And if that jurisdiction over the person is not there, no injunction can be granted. So, comity of courts is recognized in this manner.
Absolutely.
In personam jurisdiction is necessary.
An entire new topic comes around, non-parties to the contraction framework, right, which I could get you to sit back
Yeah.
here and talk about for another hour. but-
Gate.
Yes, but thank you so much on that note. And as I say, I feel like this has been a really sort of a wholehearted discussion, and I'm very grateful to you for participating and to the audience for listening. Thank you very much.
Thank you for calling us.
Thank you for calling. And thank you also actually to juniors also who helped us, at least me, in some of the research. which
Well,
was
my
there.
colleague
Though
made
most
me
of them
read
are sitting
15
here.
judgments, so I'm not sure I'm thankful.
Yeah.
Yeah, but for that I would not have been knowledgeable also about anything.
If we can pick up Paris, I think 2 after this. Thank you very much.
Thank you.
Thank you.